Hello, my name is Marcus Johnston. I'm the Senior Solicitor at PCD Solicitors. In this short video, I just want to touch on this area of historic offences. It's an increasing area of law, increasingly busy area of law, and it relates to allegations of a historic nature. Going back a number of years, it might be a number of months back, it could be several years back. In fact, we're dealing with a case at the moment with one of our clients who was accused of committing an offence 50 years ago. An historic offence. If you're accused of committing an historic offence, then please contact us early because there's a lot of work that needs to be done. If you've not yet been charged, we need to try to avoid you being charged. And we do have success in this area because it's quite difficult for the prosecution, if the arguments are put forward at an early stage, difficult for the prosecution to reach their charging standard. So for the prosecution to decide that you're going to be prosecuted, they have to be sure that first it's in the public interest to prosecute you, but also there's a reasonable prospect of a conviction. And this reasonableness test is really important. Now compare that with if you were accused of assaulting somebody last night, and this lady has come forward and said you sexually assaulted them last night when you left the pub. And there's CCTV and there's DNA, etc., then that may be fairly easy for the prosecution to think, yep, that's tips the balance. There's a reasonable prospect of success here, and therefore you could be charged and prosecuted. But compare that to the situation of a historic case a year ago, 2 years ago, 5 years ago, where a woman now comes forward and says, well, actually, this person sexually assaulted me 5 years ago. There's no DNA, there's no CCTV, there's no other witnesses. It's just the word of this one person compared to your word. And that can be very difficult for the prosecution to succeed with. However, it does mean that you or your solicitor has to put forward legal arguments to the Crown Prosecution Service before they make the charging decision, setting out reasons why the evidence as it stands doesn't reach the charging standard, that there is no reasonable prospect of you being convicted. And that's not just a case of denying the offence. One would expect that to be the case. You deny the offence. But if that's all you do, the danger is you get charged. Because if a woman has made an allegation of rape, for example, or a sexual assault, and then you say, no, that didn't happen, I deny that, it's not the job of the prosecution reviewing lawyer to decide who to believe. That's the job of the jury. That's the job of the court. So invariably you end up being charged and prosecuted, and you've then got to defend it through the court system. So what we have to do as solicitors, if we're acting for you, is not just deny the offence, but set out reasons very carefully why the evidence as it stands doesn't reach the prosecution charging threshold. That's different to defending a case. It's looking at what is the charging standard and why the evidence at that stage doesn't reach that standard. Why is there no reasonable prospect of a conviction? And that's looking at your background, your history. Have you got previous convictions, a clean record, good character? What is your relation? What was your relationship? Was there a relationship with the complainant? Do you even acknowledge knowing the complainant or having any relationship with her? What's her mental health been like over the years? What's the reasons why she would wait a period of time, perhaps months or years or several years, decades, before making an allegation? How does that affect the reliability of that evidence? These are all issues that need looking at, which we can potentially take up with the Crown Prosecution reviewing lawyer before they make the charging decision. And the aim there is to try to convince them not to charge you. So it's worth doing. In my view, there's no loss in doing that, because if you don't do that, or your solicitor doesn't do that at the early stage, the danger is you end up being prosecuted. And what happens when you're prosecuted? You've then got to defend the case, and your defence is raising all the same issues and those backgrounds, the background to the case that we'd be working on from the start. So by going through your background, the complainant's background, your relationship, what you remember about things, how strong the evidence is, what's missing, looking at all of that gives us a chance to try to stop the case going ahead. But if it does still go ahead, we're in the best place to then go on and defend the case. So nothing to lose by taking the advice early, looking at how we can try and stop the prosecution, and then solicitors, me on your behalf, contacting, liaising with the prosecution to try to avoid you being charged. Nothing at all to lose by doing that, in my view. So please get in touch. I'll be happy to go through things with you and explain how we might be able to assist in your case. But thank you for watching.